Hello, welcome back to the another virtual class of
political science.
So today we are going to continue with the same topic which we started last time, that is the judiciary of India. So in that we were discussing about the Supreme Court of India, and in that we discussed about the composition, the qualifications required to become the judges of Supreme Court. Okay, then we discussed about the tenure of the judges of Supreme Court. So all those things we discussed in the previous class. So today we are going to discuss about the jurisdictions and the functions of the Supreme Court. So let's start with our today's class. So today we are going to discuss about the functions as well as the jurisdiction of Supreme Court. So the first thing which we are going to discuss is the original jurisdiction. Okay, so original. So first of all, we need to understand about what is the meaning of original jurisdiction. The cases which comes to Supreme Court at the first instance is known as original jurisdiction. Okay, the cases which occurred and directly it comes under the jurisdiction of Supreme Court. It cannot go to any other courts over India. Like we have high courts are there, subordinate courts are there, right? So there it cannot go. Certain cases are there which will fall under the jurisdiction of Supreme Court only. So cases will be decided on any disputes which comes or falls under the original jurisdiction of Supreme Court. So what is the meaning of jurisdiction? The area. Okay, the area of area on which whose power will be there? The Supreme Court's power will be there. That means no other courts can interfere in the or working of that particular region or the area. So that is known as jurisdiction. So original jurisdiction, once again, the cases which falls under the Supreme Court at the first instance, the cases which occurred and then and there it will fall under the jurisdiction of Supreme Court. So what are the cases? Which type of cases are there which will be looked after by the Supreme Court directly without these cases being taken into any other courts? So there are certain things I have written it over here. You can go through it. Okay, if you want you can write down in your copies also. The first one is whenever there is a dispute means certain things are there which cannot be solved. Both the parties are not ready to surrender, or both the governments are not ready to agree to certain points on some legal matters, and all legal issues are there. Because in this country we have a federal form of government, right? So two forms of government are there. Union government is there, state governments are there. So there can be lot of confusion, lot of disputes can arise, and those disputes definitely has to fall under the jurisdiction of Supreme Court. So that will be decided by the Supreme Court. So here one example is given over here. Suppose for example, if a dispute is there between the government of India, okay, there is a dispute between two parties. On one side government of India is there, and the other side one state or more states are there. Suppose for example, government of India is on one side and on the other side a state is there. Any of the, suppose Bihar is there or West Bengal is there, on any of the states of India is there. Both has a dispute on some legal issues or some legal matters. So that case will fall under the jurisdiction of a Supreme Court. That will directly fall under the jurisdiction of a Supreme Court. Okay, so I said over here one, it can be one also if there are two or more states. Suppose more states are there. Suppose 5 states together on one side versus government of India on one side. Okay, if there is any dispute, then that case will be decided by the Supreme Court. Okay, next one again I have mentioned government of India on one side, any state, it can be any state. It can be any of the states of India, state or more than one state. So anything is possible. Okay, so first one government of India versus one state, or the government of India or any of the states if they have a dispute on some legal issues. Okay, on the existence of the legal rights. If there is a dispute in the laws of the government of the state as well as the union made laws, those disputes will be decided by the Supreme Court. Okay, then the third one you can see here, if there is a dispute between two or more states. Dispute between state versus state. The first one we discussed, government of India, that is union government, and the state governments. Okay, Okay, then the next, this one is all about two states. Suppose there is a dispute between the state of West Bengal and on the other side Bihar is there. So if there is any disputes related to any issues, water dispute or any other law matters are there, that suppose recently we had a problem, right? So like the Susan's mother case, that means a murder case, right? So Maharashtra government was investigating it, and the Bihar government, that means Bihar police also entered into that case. So there was a clash. Maharashtra government was not ready to allow the Bihar police to investigate the case. So that matter was taken to the Supreme Court, and finally Supreme Court gave that matter to the CBI. So CBI is investigating that case, right? So these are some of the cases whenever there is, suppose police. I told you, you might say police. Every state government, they have their own police. Okay, West Bengal police cannot go and work in Maharashtra, state of Maharashtra government, they have their own police. So police comes under the state government, under the control of the state government. Okay, so that issue was there, which was later on sorted out by the Supreme Court. So if there is a dispute between two states, one state versus another state, or one state versus two or more states. Suppose West Bengal on one side, and on the other side two states are there, Bihar and Karnataka is there. They two versus one state. So these disputes will also fall under the jurisdiction of a Supreme Court. Okay, so next one. So this all comes under this part, dispute between. So all these three I have broken into three parts to make it more and more clear. Now the second one is here. You can see here, if there is a case, okay, all such cases as involve an interpretation. So let me tell you what is the meaning of interpretation when you are to explain it in a more easy way. So the Supreme Court is a final interpreter of the Constitution. Supreme Court is the highest court as well as the final interpreter of the Constitution. Constitution can be interpreted properly by the Supreme Court. So if there is any certain disputes or any problem related to the interpretation of the Constitution, that will also will fall under the jurisdiction of a Supreme Court. So first one is cases related to the interpretation of the Constitution. Okay, then the second one is denial. If any of the person is denied the fundamental rights. So if any of the fundamental rights are denied by a government or a group of people, or if the fundamental rights of the people are infringed or taken away, then definitely that case also will fall directly under the Supreme Court. So we have been given number of rights in the name of fundamental rights. So nobody has the right to take away our fundamental rights. So if this things happens, if any of our fundamental right is snatched away, okay, or are infringed by the state government or a group of people, okay, so that means where can we go? We can directly go to the Supreme Court. Supreme Court will decide it. So Supreme Court protects the fundamental rights of the people of the country. So this power, protection of fundamental right, is also done by the high courts. Suppose for example I am in Delhi, right? So Supreme Court is there in Delhi. If my fundamental right is infringed, then I can directly go to the Supreme Court, right? If any of the person is illegally held, suppose a person without any trial is detained or kept in custody without any trial, so that case also will fall under the Supreme Court, because that person's fundamental right is snatched away. Okay, so Supreme Court protects the fundamental rights of the people of the country. Even High Court also has that power to protect the fundamental rights. Okay, so two things are mentioned over here: interpretation of the Constitution. If there is any dispute or if there is any problem related to the interpretation, Supreme Court will directly interpret the Constitution, because Constitution, many of the things, many of the people, they don't understand. So if the proper procedure and the proper meaning or the law is not properly implemented, or if not understood properly, suppose for example what I have to do according to the law, I have not done that, okay, I have taken that in a different way, so that there is a confusion. So in that period we can say that that confusion can be cleared by the Supreme Court. Okay, so that is all about the original jurisdiction of Supreme Court. So once again, what is meant by original jurisdiction? The cases which comes at the first instance. Okay, the cases which falls under the Supreme Court at the first instance. Okay, that is known as original jurisdiction of the Supreme Court. Okay, so this is all about the original jurisdiction of the Supreme Court. We'll discuss about the appellate jurisdiction of Supreme Court. So first of all, we need to understand about what is the meaning of appeal and appellate. Okay, so appellate jurisdiction. So this is the term appellate. Okay, this term comes from the word appeal. Appeal means request. In the cricket and all, you might have heard that the bowler appealed, but the umpire was not convinced. This word, this sentence you might have heard. Okay, when they say how's that, that means the bowler is trying to convince the umpire that he should give that batsman as out. Okay, he appeals, he requests. That is called request, appeal. So appellate jurisdiction means the cases which comes to Supreme Court in the form of appeal, and we can say that Supreme Court is the highest court of appeal. Above that there is no other courts where you can appeal. Okay, so Supreme Court is the highest court of appeal in all civil as well as criminal cases. Okay, so Supreme Court can hear appeal against any decision of the state high court. Okay, state high court has already given the verdict and all. Okay, judgment already has been passed by the high court, but still if you are not happy, if you are not satisfied, then you can go to the Supreme Court in the form of appeal. So many times you might have heard about the movie stars and all, the cases runs in the session court. The verdict is given, okay, judgment is pronounced, they are not happy, then they go to the high court, then from high court also same judgment they get, and from there also they go to the Supreme Court. This process continues. Okay, so it's a very lengthy process and it takes a long time to reach to the final judgment or the punishment to be given to the culprit. So Supreme Court can hear any appeal against any decision of the high court. Okay, when the case involves a major question of law. If the case involves the major question of law, okay, or any interpretation of the constitution, then that case can be referred to the Supreme Court or can be taken to the Supreme Court in the form of appeal. Okay, so normally the appeal can come before the Supreme Court when the High Court issues a certificate to this effect. So High Court definitely has to give the certificate. Yes, this case is fit to be appealed in the Supreme Court. Okay, so it doesn't mean that the judgment is given and then you cannot appeal to the Supreme Court. It's not like that. That has to be, the certificate needs to be given by the courts. If it is a subordinate court will give. So we are discussing about Supreme Court. So normally the cases will come from High Court to the Supreme Court. So Supreme Court is the highest court of appeal. Even the High Court also hears the cases of appeal which come from the subordinate courts. Okay. The first one you can see here, appellate jurisdiction in civil cases. In the matter of civil cases, how Supreme Court will hear the cases. So it is mentioned over here. Number one, the case involves a substantive. Okay, the word here you can see a substantive. Okay, means important. Okay, important. So the case involves an important question of law of general importance. Okay, the case involves a matter of general importance. So definitely that case can be appealed to the Supreme Court. That can go to the Supreme Court. So these are the civil cases. Which are the cases which can go to the Supreme Court? Civil cases. These are the matters. So if the case involves a matter of important law, okay, the case involves a substantive question of law, then that case can be appealed to the Supreme Court. Okay, the next one, or in the opinion, suppose in the opinion of the High Court, HC means High Court. I have written in short High Court. So in the opinion of the High Court, the question need to be decided by the Supreme Court. Accordingly, the High Court thinks or feels, or in the opinion of the High Court decide, no, this matter should be decided by the Supreme Court. So let them do it. Okay. Now example I can give you, like we go to a MBBS doctor. Suppose I am sick. I go to MBBS doctor, so MBBS doctor can also treat my disease, but that doctor sometime what they do, they refer us to a better doctor, right? They refer to us to a surgeon, okay? They refer to us some of the good doctors of India. So reference, he can also treat me, but he can think that he feels that no, better that particular doctor can treat this patient properly. So reference. So if the High Court thinks that the case involves the matter of a public importance or a general importance, or in the opinion of the High Court, the question, you can see here, the matter which is involved in the case, the question which is involved in the case needs to be decided by the Supreme Court. HC means Supreme Court. So this is how the civil cases goes to the Supreme Court through appeal. So appellate jurisdiction in civil cases. So this topic we discussed. Okay, the civil cases can go to the Supreme Court if this is the criteria. If the case involves the matter of public importance or general importance, or in the opinion of the High Court, the said questions in the case need to be decided by the Supreme Court. So that can be done. Okay, now next one, the appellate cases in criminal matters. So the next one which comes under appellate jurisdiction of Supreme Court is, okay, that is in the matter of criminal cases. So which all cases comes under the Supreme Court? You can see here, this is the matter. The before one was in criminal civil cases. Today now we'll discuss about criminal cases. So what type of appellate jurisdiction can be possible in criminal matters? Okay, so criminal cases. So now you can see here, you can look into it properly. Okay, so suppose a criminal case is there, right? If a criminal case is there, so under what circumstances that case will go to the Supreme Court in the form of appeal? Okay, you can see here, if the High Court, see here, if the High Court has reversed, if the High Court has reversed an order of acquittal of an accused and sentenced him to death, the order has been reversed and has been sentence him to death. So that is something very unfortunate, right? In the lower courts the decision is something different, and the High Court reverses that judgment and awards the accused into death sentence. That is not fair, right? So in that case there will be definitely a doubt, let me go to the higher court for the same case, because there is a differences. In the lower court some different judgment, in the High Court some different judgment. So when there are, the case is same, okay, crime is same, but the judgment is different. So in that case, my dear, the case definitely needs to be decided by the Supreme Court. So you can see here, acquittal. What is the meaning of acquittal? This is the word acquittal. Acquittal means a finding, okay, finding by the judge that the defendant is not guilty. The judge found that, the judges of lower court found that the accused is not guilty, okay, accused is not guilty, so he has been freed, okay, but that case will be taken by the High Court, okay, and the judgment given by the lower court will be reversed and will sentence the person to death. The acquittal of an accused and the sentence him to death. So definitely this is in the case of criminal matter. So this can go to the Supreme Court in the form of appeal, because two different things occurred over here, right? The lower court found the person is not guilty, finding in his finding the defendant is not guilty, Okay, so High Court takes the case and reverses. You can see the case. Reverse the case and awards the person to death sentence. Life, that means capital punishment, hang till death. So definitely that can go, right? Another one, or if the High Court, see here, if the High Court has withdrawn for a trial the case from a subordinate court. Suppose High Court withdraws the case from the subordinate court. Suppose trial is going in the subordinate court, in the lower court the trial is going on, but High Court withdraws that case and brings into the High Court, okay, and award death sentence. Case is going on in the subordinate court. High Court takes the case and awards the person to death sentence. So here also this case also is fit to be appealed to the Supreme Court. Okay, so actually you may think that why the case is going on in subordinate court, High Court, why he takes it. So definitely it is possible because a lot of pending cases are there. In order to provide speedy justice to the people and clear all the pending cases, this is done by the High Courts. So definitely the case is in the subordinate court. High Court takes it from the subordinate court and awards death sentence. So definitely there is a confusion, doubt. The person definitely will appeal. No, let me try the same case to the Supreme Court. So that case will go to the Supreme Court in the form of appeal. Okay. So next one, the last one, we can see that if the High Court, in the last one you can see that and last one, within that only, or the third one, if the certificates, okay, if the High Court, okay, I forgot. So if the High Court certifies that the case is fit for appeal to the Supreme Court. So High Court himself or decides that the case is fit for appeal to the Supreme Court, then that is also possible. So this is in the matter of criminal cases. So hope you all have understood this part, right? So now we'll discuss about some of the functions of Supreme Court as well as two jurisdiction that is left out, that also we'll discuss, and these are the things which are going to discuss today, and this will be the last topic from Supreme Court. Okay, so what is mean by revisory jurisdiction? Revisory, that means revise means to go through it again, like in schools and all. After completing all the chapters and all, right, the teachers gives you revision and all, they ask you to revise the chapter and all, right, that we do frequently in our school. So here in the case, what is mean by revisory jurisdiction? Supreme Court has the power to revise its own judgment. Supreme Court has the power to revise his own judgment. I pronounce judgment, but later on if I feel that no, the decision made by me is wrong, so I can do it. So before the person is hanged, before that if I realize that no, the judgment is wrong given by me, so I can revise the judgment. Okay, so Supreme Court can amend or reverse or modify or redefine any judgment delivered by it, so that they can do it. I made a mistake, so I have to correct my mistakes. Okay, so in the suppose it is a matter of life and death, a person has been given death sentence, but later on if it is approved or found that no, the decision given by the judge or given by the person is wrong, then definitely before it is too late, we can reverse the judgment, we can redefine the judgment. So that is possible with the Supreme Court. Okay, that is known as revisory jurisdiction. The Supreme Court can revise its own judgment given earlier and can define and revise the judgment. Okay, so this is revisory jurisdiction of the Supreme Court. Now next one is advisory. advisory jurisdiction. So what is mean by advisory jurisdiction? Like sometime we need advices, right? Suppose I am in trouble, I need advice, I don't know what to do, what not to do. Okay, I am about to drown into the darkness, so I need advice. So where do we go for advice? Sometime we go to ask our friends, sometime we go to the elders, sometime we go to our parents, right? So wherever we feel comfortable, we ask advice. Okay, so here which advice I'm talking about? So here advisory jurisdiction in Supreme Court means President can seek advice from Supreme Court on some legal matters. President can seek advice from the Supreme Court on some legal matters. Okay, this is clear. President can seek advice from Supreme Court. That means President can ask advice from Supreme Court. But two things I have to tell you here. The advice given by the Supreme Court is not necessary that the President will accept it. Okay, it is not that Supreme Court has given the advice, law, I have to follow it. It's not like that. So the advices given by the Supreme Court is not bound for the President to follow it. He may follow, he may not follow also. Okay, so President can seek advice of the Supreme Court on any legal matters or law or any dispute of high public importance. In such cases, my dear, the Supreme Court essentially gives advisories of opinion to the President. So here, one more thing I missed out. President may seek advice from Supreme Court. So Supreme Court is not bound to give advice. Supreme Court may or may not give the advice. Supreme Court may or may not give the advice. Okay, if given, if the advice is given by the Supreme Court, it is not necessary that the President has to follow it. Like I tell you, I give you advices. Please study properly, take your life seriously. I am advising you. So it is up to you whether you follow or not. If you follow, well and good. If you don't like, don't follow it. Isn't it? So that is the advisory jurisdiction. So that means I cannot go for advices from the Supreme Court. I cannot seek advice from Supreme Court. But who can seek advice? President of India can seek advice from Supreme Court. In High Court, Governor of the concerned state can seek advice from High Court. So High Court also has the advisory jurisdiction. Okay, so here President can seek advice from Supreme Court on some legal matters. Okay, on any disputes or any important public opinion is to be generated. The President is confused what to do, what not to do. So in that case, he can seek advice from Supreme Court. So that is the advisory jurisdiction of a Supreme Court. Okay. Now the fifth one is protection of fundamental rights. So definitely Supreme Court is the protector of the fundamental rights. Supreme Court is the protector of the fundamental rights. Even High Court is also the protector of the fundamental rights. So how does Supreme Court protect the fundamental rights? So by issuing writs. Supreme Court protects the fundamental rights of the people by issuing writs. W-R-I-T-S. You can see the word. So what is writs? Writs are the certificates of order issued from the higher court to the lower court, okay, to remind them to do their work properly. Okay, so there are number of writs. There are number of writs like writ of habeas corpus is there, writ of mandamus is there, writ of prohibition is there, writ of quo warranto is there, and writ of certiorari is there. So this part we have discussed earlier in class 9. Right, so we have already discussed this, so no need to discuss over here. So Supreme Court protects the fundamental rights of the people by issuing writs. Okay, so that is how Supreme Court is the protector of our fundamental rights. So protection of the fundamental rights is done by the Supreme Court. Now number 6, judicial review. So what is the meaning of judicial review? What is the meaning of a judicial review? So let me tell you, my dear, review. Laws are passed in the legislature. Laws are passed in the legislature. So I was talking, laws are passed in the legislature, right? Lok Sabha is there, Rajya Sabha is there. They are the final houses which decides the law. Parliament is the lawmaking body, we know it. So there are some laws which are passed by the legislature. So Supreme Court has the power of judicial review means the laws which are passed by the legislature are checked by the Supreme Court whether that law is as per the constitution or not. Okay, so it is not that all the laws are checked by the Supreme Court. It's not that. If any of the law passed by the legislature is challenged by a person or a group of people, then definitely the validity of the law will definitely be checked by the Supreme Court. That is known as judicial review of the Supreme Court. So it doesn't mean that a law, whichever party is there, they can make a law of their need. So that is not possible. So whenever the laws are passed in the legislature, one thing must be kept in mind, that the very basic of the constitution must not be changed. The structure of the constitution should not be changed. Okay, suppose for example I want to renovate this room, I can paint the walls, but I cannot simply that means demolish the pillars and all. A new building I cannot make it. That is not possible. So law, constitution is there, we cannot change it, but certain changes if I do for my benefit and that is harmful for the people, then if that law is challenged by the person or a group of person, then that part will be checked by the Supreme Court whether that law passed by the legislature is as per the Constitution of India or not. If it is found that the law passed by the legislature is not as per the Constitution, then Supreme Court will declare that law as null and void. Null, N-U-L-L, null and void. That means from that day the law will cease to exist. That law will not at all continue. So that is the importance of judicial review. So once again, the laws are passed by the legislature, but some laws which, if possible, if challenged by the person, can be checked by the Supreme Court regarding its validity, whether the law is as per the Constitution or not. If it is found that a law, entire law or a part of the law passed by the legislature is not as per the Constitution, then Supreme Court will declare it as null and void. From that day, the law will stop to function. Hope you understood this part. Okay, so this is judicial review. Okay, now next one you can see here, the last one, Supreme Court as the court of record. Supreme Court is also known as the court of record. So definitely Supreme Court is a court of record. Every court, whether it is a Supreme Court or High Court or any other subordinate court, all these courts keeps all the record. Any judgment, any proceedings which takes place in the Supreme Court are recorded. Like in movies and all, you might have seen a judge sits on the highest table and below that one person is there, he is typing something on the paper. What is he doing? He is recording everything. The proceedings which goes on in the Supreme Court are recorded for future testimony, and those records later on are studied by the lawyers. They refer the cases, and even it is helpful for the law students also. Okay, so it is mentioned over here, Supreme Court is a court of record. Its judgment bind all courts in India. Whatever judgment is given by Supreme Court, that binds over all courts in India. All courts of India can use the judgment delivered by the Supreme Court. Supreme Court has delivered a judgment on a particular case, same type of case. If the same type of case is there in any of the part of the country or in any of the high courts, the same judgment has to be given, because there cannot be two judgments for the same thing. Suppose I have committed a similar crime, for that already a judgment has been given to somebody else, the same judgment has to be given in that case also. Okay, so Supreme Court is a court of record. All the proceedings which takes place in the Supreme Court are recorded for future testimony, and it is referred by the lawyers as well as law students in their colleges. Okay, so that is the importance of court of record. Okay, Supreme Court is a court of record. Even High Court is also the court of record. Even the High Court is also the court of record. So hope you all have understood this part. So today we discuss again here revisory jurisdiction, advisory jurisdiction, protection of fundamental rights. Supreme Court is the protector of fundamental rights, judicial review, and Supreme Court as a court of record. So this is all about from the Supreme Court chapter, the judiciary chapter. Okay, so hope you all have understood what I taught today. So we'll meet again in next class. So till then, take care, stay safe, bye bye.